Well, hello there and welcome to the Disability Law Show. Once again, John Scholes, your host, and joining me, James Fireman from Samfiru, Tumarkin, LLP. He's the guy with all the knowledge and the smarts. There he is. And you will learn lots over the next 30 minutes, so stay tuned with us. And you can join the show anytime via email, help@disabilityrights.ca. And if you want to reach out to James anytime you would like, real simple, 1-855-821-5900. I'll give you some more contact information throughout the 30 minutes. But main topic a little later on the show, how to protect yourself from bullying and harassment from an adjuster. That is coming up in just a bit. James will fill us in that regard. But we always get started, brother, with the case of the day or the week that was. What's happening on your end?
Well, there is a medical issue that I'm seeing pop up on several of my files recently. And I think it's something that we haven't spent a lot of time over the years talking about, and it's concussions and the impact of concussions, not just on your health, but on the disability insurance process. So first of all, when we're talking about concussions, a concussion is by definition a brain injury. People don't think about it in those terms, but literally that is what a concussion is. Now, I'm not going to become a doctor here, but concussions can be anywhere on a continuum from mild to severe. And thankfully for most people, when they suffer a concussion, it's a mild concussion. And what we understand about that is most mild concussions will resolve in a matter of days or weeks. And for some people, if you're really lucky, you won't even have any ongoing symptoms, which is wonderful. But most people isn't all people. There is a certain percentage of people who suffer even a mild concussion and have ongoing symptoms. Some of them can even be quite severe and develop over time. And there are a few factors that are well understood to contribute to that, where the outcome isn't necessarily as likely to be so positive. So one of those is if you have previous concussions. We understand from medical research that concussions can actually be a compounding factor. So if you have several concussions, especially if those concussions are in short order, if you have one shortly after having another, the impact of that can be really, really difficult. It can lead to worse results and a much longer recovery time. So that is a really big factor in looking at how long a concussion is going to take to resolve. And then also you have to look at mental health. Mental health is a factor both before and after. Somebody who has a history of significant mental health issues is likely going to have a longer recovery time and a worse outcome even from a mild concussion. There is research to support that. Likewise, somebody who has a concussion, even if they don't have any previous mental health issues, is also likely to develop mental health issues afterwards. These are things that we understand from research. None of them are certain, and for most people, you have a mild concussion, you are probably going to make a full recovery, which is great. But so this brings us back to disability insurance, which is the whole point of this. And so what I see fairly consistently is where someone suffers a concussion and does not have that very quick turnaround where they recover in a matter of weeks or even a couple of months. You see the disability insurer deny the claim and cite the research that suggests that most concussions are going to resolve very quickly, and therefore you should have recovered, and therefore we're denying your claim. But again, most is not all. And so if you have had a concussion and you have ongoing symptoms starting from the concussion or shortly afterwards that have not resolved, and those symptoms are preventing you from being able to function in your job, then that is something that should entitle you to disability benefits. Even though your insurer is saying, well, most people recover, therefore we're denying. A concussion is absolutely a compensable condition under a disability insurance policy if the symptoms are preventing you from returning to work.
Why is this such a big bone of contention with insurance companies? Because it's, again, we often talk about that mental impairments and disabilities because it doesn't appear on an X-ray or an MRI. They like to deny and fight, but a concussion will show up on medical scans. Why is it such a difficult thing? And yeah, plus you have your doctor's opinion as well backing you up.
Well, so it's interesting. Mild concussions often won't, which is exactly why a lot of insurers will deny that. That doesn't mean because the medical imaging doesn't show the positive result from a concussion that you don't have one. It is actually well understood that mild concussions will not show up on that. Now, medical science, as I understand it through my research on this, has actually advanced to the point where if you have if you have access to the most advanced technology available, you can actually detect it. But the practical reality for most people is they're nowhere close to that technology.
Right.
The standard technology that would be used, especially for a mild concussion, is not going to reveal that. So that's number one. That's the reason why. But number two is what we already understand about the disability insurance process. Insurers are looking for an easy out. They're looking for a justification in order to be able to deny the benefits. That's how they make their money. We know that. And a concussion is in and of itself an easy out because we know most people are going to resolve. Their conditions will resolve in a matter of a few weeks or so. And the insurer just relies on that and says most people do, therefore you ought to have, therefore we're denying. But I can tell you with a high degree of certainty that if you are able to substantiate the concussion, if you have support from your GP, if you've been sent to specialists and you're being treated for concussion and your insurer is still denying, especially if you have pre-existing mental health issues or previous concussions, then there is a very good chance that you're going to be successful if you bring a lawsuit, if you bring a legal claim to challenge the denial.
Want to make you aware as well, a website fairly new. It's only been around a short time, called pocketdisabilitylawyer.ca. It's cool because even before the phone call to James and his team, not that you don't want to make the phone call, right? But if chance you want to find out, do I possibly have a disability case I can take up with the firm? James, it's a good website to go to, right? Pocketdisabilitylawyer.ca.
Yep.
I know it's new for you guys and you've had some experience with it, and people have been calling out and reaching out after using that website. So again, pocketdisabilitylawyer.ca, and the phone number, of course, 1-855-821-5900. Want to get to an email. Liam, first one of the show. Again, help@disabilityrights.ca, says, I suffered a brain injury a year ago and have since experienced debilitating migraines and other chronic symptoms. My doctor strongly advised me to take time off from work as a financial analyst to recover. I was initially approved for LTD, but my benefits were cut off because I allegedly failed to comply with the recommended treatment. I'm on a wait list to see a specialist. How is this possible?
So I want to just go back to what I was talking about initially.
Yep.
Liam is suffering from a brain injury, and he works in an occupation where, as a financial analyst, where obviously executive function is really critical.
Yeah.
Being able to think quickly, to be able to work through things logically is critical in that kind of a position. And if you have a concussion, if you're having cognitive symptoms, if concentration is difficult, if your memory is in any way impaired, if you have significant fatigue all day, which are all very common symptoms for people who are suffering from concussions, you're not going to be able to work. That doesn't mean that you are in bed all day and you're not capable of functioning. What it means is you're not able to function in your occupation. And that is especially a concern for people who are at occupations that require that level of executive function. Now, getting to Liam's specific question, it's a little bit different. So here the issue is getting the recommended treatment. And the recommended treatment in Liam's case is to be provided by a specialist. But one thing that we understand is that getting medical treatment in this country across the board is pretty difficult. It gets worse when you move away from urban centers, but even in urban centers, Toronto, Calgary, Vancouver, Montreal, Ottawa, it's still difficult.
Yep.
The wait list can be 6 months, a year, 2 years sometimes for psychiatric care. I've seen that.
Wow.
So it's not uncommon for people to not have access to the treatment that they absolutely require, specialized treatment in order to care for whatever condition that they have. So where does that leave you with the insurance company? Because we know if we look at the policy is going to say if you want your benefits, even if you have a disabling condition, in order to receive those benefits, you have to show that you are getting reasonable treatment. So what happens in this scenario where you literally cannot get it?
Right.
Well, there are situations, and Liam's is a good example, where insurers will try to use that as a sword and say, well, it's not up to us to get you treatment. You're not getting it, so we're not going to pay. That doesn't work. They know that. The insurance companies well understand that if this were in front of a judge would not accept that as an answer. As long as Liam is doing everything that he can, everything that is reasonably available to him. So in this particular case, there's a specialist that he cannot get to see for some period of time. But there may also be 3 or 4 other recommended forms of treatment, whether it's medication, whether it's a particular type of therapy, whether it's counseling. There may be other things that he can do that aren't necessarily the whole answer, but they are part of a broader treatment program. And so as long as he is doing those other things that he doesn't have to wait 6 months or a year to start, then the insurance company is in no position to say you're not getting reasonable treatment. If it isn't available and you've got the referral and you're doing everything that you can, that is simply not an answer. That is simply not a basis that the insurance company can use to deny a claim for disability benefits. And if they do that, as in Liam's case here, once we start a legal claim, the insurer is going to come to the table really, really quickly.
Yeah.
Because this isn't a gray area. Insurers know that they cannot do this. And when they've done it, when it's very clear that the only issue is access, it's not an unwillingness, it's just access, they know that they're now exposed to punitive damages, which means not only having to pay the benefits that they would have had to pay anyway, but it means also having to pay for the fact that they are acting unreasonably. Their process is fundamentally unfair because they're requiring something that is actually impossible. And when that happens, a judge looking at it may well say, you not only have to pay the benefits, but you have to pay damages on top of it for bad faith.
And with that, we'll get into our first break. When we come back, how to protect yourself from bullying or harassment from an adjuster. In the meantime, reach out to James and the team, 1-855-821-5900. Help at disabilityrights.ca as well. We'll continue with the Disability Law Show. Stand by. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Disability Law Show. James Fireman here, Samfiru, Tumarkin, LLP. Reach out anytime to James and his team, 1-855-821-5900. Help at disabilityrights.ca. And you can also go to pocketdisabilitylawyer.ca to learn much more and find out if you qualify to move on and upward with James and his team. Okay, main topic for the show, as I mentioned, James, how to protect yourself from bullying or harassment from an adjuster. Number one, you want to ensure all concerns about your insurer's behavior are documented in writing. Always.
Yeah, this is probably the best tool that anybody involved in the disability insurance process has, is making sure everything is documented in writing. Certainly that applies to this situation when we're dealing with an aggressive or bullying claims handler or adjuster. You want to make sure that that is well documented. And what I would caution anybody who's watching this program about is trying to characterize anything in a particular way. So to actually say you're harassing me or bullying me in that particular language is something that is a matter of opinion. But what you can say are whatever facts are applicable to that. So in other words, what you can certainly do is say, last week you called me on Monday and Tuesday and Thursday and Saturday, or 3 times on Saturday, or what have you. You also emailed me on this day, on this day, on this day. And as a result of having done that, that made me feel da-da-da-da-da-da-da. So it's not saying you are bullying me, you are harassing me, even though that may well be how you are feeling about it. It is literally just reciting the facts of what has happened and how that is impacting you. And as long as you have that record there, showing that this is what has happened, this is what has been said to you. So if during those calls the claims handler has said something that you found to be offensive or has characterized something that you've done in a particular way that is incorrect, or has done anything that has set you off, I would put that in the email as well too. Again, you're not trying to necessarily characterize what they've said. You're literally just reciting what they've said as close as you can to verbatim. You may not be able to do it word for word exactly, but what is really important is that you capture the substance of what they are saying. Get that in writing. Send that in an email to the claims handler and say, this is what has happened. And I would certainly suggest in doing that, asking that either they only contact you by email or that they change claims handlers if it really is an issue of this particular claims handler and you think that they are bullying you, and give them your reasons why you feel as though their presence on this particular file is leading to an exacerbation of mental health symptoms, especially if your disability is a mental health issue. It's really critical that you put that out there. It doesn't mean because you request it that they're going to comply, and I wouldn't expect that they will. But you should make the request anyway, because if they don't comply, that is yet one more thing down the road where if this were to ever wind up in front of a judge, we can always point to and say, here was a very reasonable request early on that would have been quite simple for the insurance company to comply with, and they didn't. And they didn't. And they understood the impact it was having on this individual, and they still did not comply. So it is critical that whenever something happens, particularly when we're talking about bullying or harassment, that it is documented. And if after documenting it, the insurance company or claims handler doesn't write back within a very reasonable amount of time and say, oh no, that's not my recollection of it, it's A, B, C, and D, not X, Y, and Z, then your version of the events that you have sent to them is essentially going to be accepted by anyone down the road as being the correct version.
Silence is compliance. Right?
Exactly. If the insurance company doesn't say anything for 6 months, no one's going to believe 6 months down the road that now all of a sudden they have a recollection that's better than what you put on paper the same day.
Yeah.
That is just common sense. So put it in writing, make sure you get that out there as soon as it happens so that there is this record of it.
Again, dealing with bullying and harassment from an adjuster. Number 2 is this, James: contact your doctor if your communications have led to health complications. Wow.
Yeah, so this is actually really just the other side of the same coin. So as much as we want to make sure that we're documenting our issues with the claims handler, so it's going to show up in the insurance file, we also want to make sure that we're identifying these issues with our medical team. And if you're suffering from a mental health issue, if you have depression or anxiety in particular, and you are feeling as though you're being bullied, you're being harassed in any particular way by the claims handler, you want to make sure that you raise that with your GP, raise that with your mental health specialist, whether it's a psychiatrist or a therapist, for a couple of reasons. Number one, first and foremost, so that they understand that this is part of what is happening to you and they can help you deal with that. And I won't even begin to suggest how they might do that. I'm not qualified, obviously, but it certainly is important that you bring it to their attention so that you can deal with it from a medical perspective. Number two, it's then identified as being a factor in your medical condition. And that has two impacts. Number one, it further supports the claim for ongoing disability benefits. Number two, to the extent that your medical condition becomes significantly worse as a result of how your insurance company is treating you, especially if that treatment is inappropriate, then once again, the insurance company is opening themselves up to a claim that they've acted in bad faith. And if a judge were to ever find that, it means not only are they on the hook for the benefits that they would have owed anyway, but now they also are on the hook for punitive damages. And they would want to avoid that at all costs. So by putting it out there, what you are doing is it's essentially telling the insurance company they really want to make sure that they take a hard look at the behavior here and consider whether or not they want to pull back. They may not, but if they don't, there is a consequence to that, especially once you start a legal claim.
Let's get to our last point for this one, James, about bullying and dealing with that adjuster. Seek legal advice from a disability lawyer like you if unsure of your next steps or options, which should almost be a no-brainer at that point.
Yeah, 100%. So this is really critical no matter what stage of the process that you're in. Certainly if you are just starting your claim and you're having an issue with the claims handler in the initial phone call, or you feel like they're not really listening to you, we're happy to help you through that process in any way that you like. And we've talked about some of the resources that we can offer in that regard. So it starts with the pocket disability lawyer is a good starting point. It's a way that you can just dig in and see whether or not your situation is one that might actually lead to a legal claim. But number two, and this might be more applicable when we're talking about this sort of situation, is the FAQ on the Samfiru Tumarkin website, which is broken down into several dozen topics, including this one. And it's going to give you some broad information, and it'll be really useful for you. So much of what I've already spoken about, you could actually find on the FAQ on our website. So you don't have to sit here taking notes or record me or have to look at me while you're doing that. You can actually just go to the website and find that there. But number three, if you have a situation that is unique, that is calling for some more information that goes beyond just what's in the FAQ, we are always happy to consult with anyone who's having a problem. Our consultations are free of charge. And if it gets to the point where we need to step in, then that's what we're there for as well.
Short little break coming up here. As James just mentioned, ltdfaq.ca. ltdfaq.ca is where you want to go, or make that phone call to follow up, or ahead of that, whatever, 1-855-821-5900. More of the Disability Law Show is just ahead. Stick around. We're coming back.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back to the Disability Law Show. John Scholes here. James Fireman there. Reach out to James, Samfiru Tumarkin LLP. That's the name of the firm. The number to call, 1-855-821-5900. I will give you yet another email, or at least another address you can use to reach out to James and his team to ask questions. mydisabilityquestions.com. mydisabilityquestions.com. And from it, James, we got Beth on the show today. Says after almost 6 months on long-term disability with a herniated disc, the adjuster has requested I attend an independent assessment. I've been told it's necessary for the next phase of disability benefits. Do I have to attend despite my doctor's and therapist's belief I am unable to work?
So I want to separate out the concept of assessment versus treatment. Mm-hmm. When your insurance company wants to send you for an assessment, that is something that they are reasonably entitled to. Yep. So if they say we are setting up an appointment for you to see this particular specialist, this psychiatrist, this orthopedic surgeon, whatever your issue is, the relevant specialist, the insurer says, we've set up this appointment and this is where you have to go and you're going to do this assessment on this day, be there at this time. Okay, they're entitled to that. They are entitled to get an expert to examine you in person, review your medical notes, and provide them with their own view of what your medical situation is and whether or not you would meet the definition of disabled under the policy. They are absolutely entitled to that. Now, there are limits on that. They can't send you to 8 assessments in 2 months, obviously, and they can't send you for assessments for specialties that have absolutely nothing to do with your disability, but that's not really a problem that we see on a day-to-day basis. Typically speaking, insurers aren't interested in overspending on assessments. It costs them money, and insurers don't like to spend money if they don't have to. So if your insurer is asking you to go see an assessment, even if all of your doctors, as in Beth's case, are saying, There is no way you can go back to work. We know that for sure. Even then, your insurer is entitled to get that opinion from a doctor that they choose. And there is good reason for people to be skeptical about the doctor that is chosen by the insurance company to do the assessment. I understand that skepticism and I share it. But what I will tell you is that when disability insurers send their insureds to a specialist for assessment, usually what I see, actually, I have to acknowledge, I see usually fair assessments being done. And it is not at all uncommon for me to see the assessor chosen by the insurance company say, no, this person is in fact disabled. They cannot go back to work, or at least they can't go back to the job that they had before. Wow. I do see that fairly regularly, and so I have at least some faith in the doctors that are chosen by the insurers to do the assessments. Now, again, I started this by saying we have to separate out assessment from treatment. Okay. Treatment's a whole different story. So your insurer can demand that you're getting reasonable treatment, but what constitutes reasonable treatment is a matter of opinion, and it's certainly a matter of medical opinion. And when it comes to that, I cannot stress enough that you need to be listening to your own doctors. You should not be taking medical advice, and what treatment you're getting is the most fundamental medical advice that you can be getting. Yeah,
that's right.
So when you're talking about what treatment you should be receiving, that advice should be coming from your own doctors or your own medical team. It shouldn't be coming from your insurance company, shouldn't be coming from your lawyer. It should be coming from your doctors. That is who you rely on for medical advice. And so if your insurance company is saying, okay, well, you need to be getting this type of therapy and you need to be taking this medication and this treatment, they can have that opinion and they might even be right, but that doesn't mean because they say it that you automatically do it. When that happens, you take whatever the insurance company's opinion is and you bring that to your own doctors and you say, this is what I'm being told by my insurance company. Is that reasonable? Should I be taking this medication? Should I be going for this treatment? Yeah. And if your doctor says no, I cannot stress strongly enough that you should be listening to your doctor. If your doctor says no, get them to put that in writing and make sure that's submitted to the insurance company so that they can review. Now, there is a practical reality here in that scenario. If your insurance company is saying that you need to get this type of treatment or take this kind of medication, and your own treating doctors or specialists are saying, no, that's inappropriate, that's going to either not do anything or worse yet, make your situation worse, exacerbate your symptoms, and you decide not to do it, there's a very realistic possibility that your insurance company will cut off your benefits. That is a practical reality, but it is one that I would strongly urge people to accept. Because if they cut you off in that scenario, where your own doctor has told you that the treatments being required by the insurance company are inappropriate, they cut you off in that scenario, again, they're not only opening themselves up to a claim for benefits, which will succeed very quickly, but also a claim that they've acted in bad faith and therefore would be required to pay you damages over and above the benefits that you are already entitled to. And that's something that no insurance company wants to expose themselves to. So when you're in that scenario, if you're getting recommended, or if your insurance company is telling you you need this treatment, run it by your doctor first.
Always, right?
Unfortunately, if it's an assessment, nothing you can do about it. You have to go. But hopefully, it'll be a legitimate assessment and it'll help support your claim.
And with that, we got to go as well. We are out of time. Thank you so much for your contributions through email and mydisabilityquestions.com. Keep sending them along. They may appear on a future show, so how about that? In the meantime, reaching out to James and his crew, really simple. Again, 1-855-821-5900, help@disabilityrights.ca. We did mention pocketdisabilitylawyer.ca. That's a good place to start. There's also contact information on that website, but just make that phone call if you want it right off the top to get a hold of James and his crew. Thank you so much for joining us. Keep sending those emails along, and we will catch you next time right here on the Disability Law Show.